Thank you for joining us for our series on estate planning. I would like to start by introducing myself and my colleague. My name is Zach Mangels, and I'm joined by Lisa Peters. We are both wealth managers and partners at Private Ocean. Private Ocean is an independent, comprehensive wealth management firm working with individuals and families to optimize all areas of their personal finances. Our offices are located in the San Francisco Bay Area and Seattle, though we do work with clients all over the country.
As wealth advisors and fiduciaries who understand that financial goals and planning drives our client success, it's our role to be engaged in every aspect of their financial life. Cash flow planning, debt management, business planning, tax planning, finally, estate planning. We're, in fact, generalists who work with other professionals in helping our clients build an up to date financial plan. We serve clients best when we can collaborate with our other advisors, such as a lender, the CPA, and the estate planner. It saves our clients time, and they're confident that everything is working in tandem. And because we're generalists, we don't dispense specific tax advice. However, our work requires that we're conversant with strategies and understand how an estate plan is put together.
And I think before we go any further, let's define what we mean by estate planning. So, the simplest definition of estate planning is that it directs how assets are transferred to others after you pass away. But there's actually a lot more involved, including naming people to make both financial decisions and healthcare decisions on your behalf, should you become incapable of doing so, as well as raising your children should you pass away prematurely. It can be a very morbid topic, but it's a very important one for everybody to deal with.
And our objective for this series is to provide a little education about the estate planning process, acquaint you with the documents and strategies important for people in different stages of their lives. And ultimately, we hope to nudge you into taking action and getting an estate planning done or revise the one you have. Along the way, we'll note some differences in how California and Washington state residents might think about certain aspects of their estate plan. And so we've got this series broken down into four parts. Estate Planning 101 is a series in which we'll familiarize you with the documents and definitions you should know about. Part two is frequently asked questions. In part three, we're going to meet Bob and Carol Bender and understand how they might make important estate planning decisions as younger adults. And finally, part four, we follow the Benders into their 60s as they think about leaving resources to family and important causes.
This is a very important topic to Lisa and me, which is why we wanted to put this series together. For myself, I have a 2-year-old at home, and I find myself looking at her from time to time and thinking, I need to do everything that I can to make sure that she's well taken care of and that she has the resources that she needs to live a good life. And an estate plan is a critical part of that solution. But estate planning is also important for 18-year-olds who, for the first time in their lives, are finding that they actually need to name people to be their financial and medical decision makers. It's, of course, also important for people in retirement who are thinking about what kind of legacy they want to leave behind after they've worked so hard all of their lives to build up a net worth. And then, of course, it's for everybody in between. The unfortunate thing is that the prevalence of estate planning has actually decreased in the last several years. And this is according to a study done by caring.com, which they do annually. They also found that individuals who are under the age of 55 have estate plans at dramatically lower rates, somewhere in like the 20% level, versus those who are over 55, and they have it at a higher rate, around 50%. But frankly, I think that that's still pretty low.
Yeah, you would seem natural that those folks who are approaching past age 50 into their 70s would most likely have an estate plan. But it is really surprising to me, those under age 55 who don't, because of those critical elements we need to have in place. So in part one, we'll talk more about those elements are. We hope you enjoy the rest of our series on estate planning. Welcome back to our estate planning webinar series. I'm Lisa Peters, and I'm joined by my colleague, Zach Mangels. In our introduction, we defined estate planning. Most people understand estate planning directs assets at death, but there's much more, including naming important individuals to take on decisions if you're incapacitated. Zach, would you mind elaborating more on the risks of not having an estate plan?
Yeah, certainly. And hopefully this will serve as additional motivation for anybody watching this video and who doesn't already have an estate plan in place. So, what are the risks of not having an estate plan? I think basically without it, decisions about your medical care, your property, your assets, and even your final arrangements are going to be made without your input. So, medical decisions will fall to the treating doctor or the hospital. Your property and your assets will be divided and distributed at death according to state law, and your final arrangements might be carried out according to the whims of a relative or in accordance to local customs. And then, of course, if you have children who are minors, they may end up um, being taken care of by guardians who you wouldn't have chosen yourself. So effectively, in all instances, without an estate plan, things might not go the way that you would like them to go, and your survivors could be left to deal with the ramifications. And I think as it is, when somebody's passing away, it's already a very emotional time for the survivors. And if you layer on top of this idea that they need to make some decisions on behalf of their loved one that maybe they aren't sure that the loved one would make themselves, it can make it an even more stressful and an even more emotional time. I've personally found that the clients that I have who are most adamant about having an estate plan in place are the ones who've been involved in the passing of a loved one who didn't have an estate plan themselves. So now that we know a little bit about what can go wrong without an estate plan, let's talk about the elements that are common to all estate plans. And so there's 5 documents that you'll find. You have the financial power of attorney, the medical power of attorney, advanced healthcare directive or living will. Then you'll have a will and a revocable living trust. So I'm going to dive into each of these in a little bit of detail and explain them. We're going to start off with the financial durable power of attorney. So this document sets who makes financial decisions on your behalf should you become unable to do so yourself. Many people will name their spouse, their parent, a sibling, adult children, close friends. You can really name anybody to fulfill this role for you. There's a couple of terms I think are important for this document. You've heard me say the word durable already. Durable means that this document and the powers that it authorizes this named individual will last through your own disability. So you put it in place now, you become disabled, this financial power of attorney is still in effect. It does stop, though, when you pass away. Another feature or term to know is the term called springing. And these powers of attorney, both the financial and the medical one, they can be made either immediate or springing. Immediate means that they're effective right away. You sign on the dotted line, and whoever you've named has the power to act as your financial or medical power of attorney right away. Springing means that a certain condition needs to be met, and typically that condition is the signature of 2 different doctors. I've heard different attorneys come down on either side of this. More attorneys I find suggest making the power immediate rather than springing. And I think that the rationale is, if you are willing to have somebody make financial decisions for you while you're incapacitated or unable to do those yourself, you'll probably also feel comfortable with them having that power while you are capable. Not giving advice on this. This is just what I've heard from estate attorneys. The second document is the medical power of attorney, and this sets who is going to make medical decisions on your behalf should you become unable to do so. And like I already said, those concepts of durable and springing apply to this as well. The third document is the advanced healthcare directive. Some states call this the living will, and this sets the conditions under which you do or don't want life-sustaining treatment. This is also where you can specify funeral arrangements, organ donation, things of that nature, all found in the Advanced Healthcare Directive. The fourth document is the will, and the will directs how assets in your estate are distributed after you pass away. You can give money to any individual or charity that you want, and you can even control the manner in which they get access to your assets. You can direct how debts are paid, how taxes are paid, and if you have a pet, you can even name somebody to care for the pet. Of course, if you have minor children, this is also going to be the area where guardians are named. One of the things that I think is most important to talk about for the will, especially as it compares to the trust, is that the will is probated in court. And probate is a legal process that manages the distribution of assets and liabilities left behind by somebody who's recently passed away. And Lisa and I will both come back to this topic of probate in a minute here. The fifth document is the living trust, and this directs how assets that are a part of the trust are distributed after you pass away. I think the easiest way to think about a trust or a living trust is just to think of it as an extension of you, or like your own personal company or LLC. You're the CEO of your trust, but other people can become the CEO if you're unable to be. So, one of the questions clients ask me is, if I have a living trust and I put assets in there, are they taxed any differently? That's not the case with trust. Like I said, literally just think of it as an extension of you. It's kind of a wrapper around all of your assets that governs how they are passed along to heirs if you pass away. A couple of terms to know: the word revocable, you'll see frequently accompanying living trust, and it means exactly what it sounds like. You can revoke this trust at any time. You can change the terms. And revocable would be in contrast with the term irrevocable. So there's an irrevocable trust, which when you think about a trust fund, those are quintessentially irrevocable trusts, whereas a living trust is completely revocable, changeable at any time. And one of the key things, again, that differentiates it from the will is that the living trust does not go through probate. The assets are distributed by the trustee of the trust. So, Lisa, you and I both live in different states, and each of our states has a different view on how they use the will and the trust. So maybe you could spend a little time talking about how it's handled in Washington.
Yes, in Washington State, it's not as frequently used, the revocable living trust, as just a plain standard will. Our probate process is much less burdensome and expensive. And so rather than having the revocable trust that avoids probating assets, wills are typically sufficient as long as all the property you own is in the state. And if you own property outside the state of Washington, there could be other considerations. Your attorney might recommend a revocable living trust. One other important difference is that Washington state has a much lower threshold for paying estate taxes than California or the federal level. And we'll talk more about that in Part 4. How do wills and trusts work in California?
So in California, the probate process, that court process that wills go through, is known to be extremely slow and very expensive. And it's also a public thing. So you can read how the estate is distributed. It's public knowledge, but the public has access to it. The trust, like I said already, overcomes these issues, and the estate can actually be distributed much more quickly at a fraction of the cost and in private. So wills are still used in California, and their primary purpose, aside from naming guardians, I would say that's a very important role for the will. But its primary purpose is to pour over or to transfer assets into the trust that the person forgot to do so. So in the state of California, you'll often hear of the will referred to as a pour over will because it's pouring over all of the assets into the trust.
Great, thanks. I'd like to mention an important topic that we sometimes forget about, and that is because we're in the age of digital assets. We have social media accounts, we might have documents online. It's very important to ensure that your executor or trustee is specifically directed on what to do with your online information and passwords to access them. I'm sure others have encountered this who've settled estates, but I had a client whose twin brother passed away unexpectedly. He had an estate plan, but he did not really reference anything in the way of passwords or online accounts. And so, unfortunately, my client couldn't access information to let his contacts know about his passing. So, it highlights a really important area. We wanted to comment here about some elements of the estate plan that are frequently misunderstood. There are certain assets that have beneficiary designations, retirement plans like 401ks, 403bs, deferred compensation, life insurance, annuities. The disposition of these assets is not governed by the will or the revocable trust. These assets will flow directly to individuals or charities via a beneficiary feature. Similarly, accounts that are titled in the name of joint tenants with rights of survivorship or transfer on death accounts also pass via beneficiary designation. Now, you can name your estate or a trust as a beneficiary of one of these accounts, and that account will then flow into your broader estate plan. Your attorney will review and recommend what beneficiary designation should be named as part of your overall estate plan. There are also some additional supplemental estate planning resources we find very helpful. And these aren't legally binding documents. We have another webinar titled Sharing Your Financial Values with Your Family that highlights a couple of these documents. So I'll just mention them briefly here. The first is a financial inventory. This is a summary of the family property, a one-stop depository of information where family members can find everything: location of documents, online passwords, professional contacts, healthcare providers, and those monthly subscriptions that might be on auto pay that might need to be stopped. There could be information about alarm codes, outstanding debts, or money owed. So it's a one-stop place to basically prevent your family members from having to do a stressful treasure hunt in finding all the details of your financial life. The second is a letter to family and friends, and this gives details about what you'd like your financial arrangements and services to look like. It might include organ donation and can include references for caring for a pet and distributing things of sentimental value. And lastly, an ethical will is a template in which you could share family values, expectations for your children or grandchildren. It can give your family greater insights as to why you assembled the estate plan that you have. It's not unusual to have property passing to children, maybe not equally, but certainly equitably. Please reach out to me, your advisor, or Zach if you'd like a copy of these resources.
I'd also like to quickly plug the ethical will too. I think it's a great document. You know, you'll find that your primary estate documents, the 5 ones that I talked about earlier, are full of legalese. So not only does that mean that it's hard to read, but for your family, it can also feel really cold, and it doesn't provide any context for the decisions that you've made. And I think that that's where the ethical will comes in. My mom passed away when I was 19, and she wrote letters to myself and my brother that we still have. And you know, it's one of the most important things that we carry with us. And she also, next to all of her, or with all of her jewelry, she hand wrote how she got it, why it was important to her, what she wants us to do with it, and things like that. And it just provided a level of insight into what my mom was thinking that we would have never otherwise had. So I'm a huge proponent of ethical wills for anybody to use. So that brings us to the end of our first part on estate planning. We've talked about the 5 basic documents that make up an estate plan. We talked about the kind of assets that transfer outside of those 5 basic documents. And then we reviewed 3 supplemental documents that can also help round out the estate plan, and which we can provide to you if you'd like those. So we hope you've enjoyed this overview on estate planning. Please stay tuned to our next section, where Lisa and I discuss the questions that we hear most frequently from our clients. Welcome back to our series on estate planning. My name is Zach Mangels, and I'm joined by my colleague and fellow advisor, Lisa Peters. In this section, we are going to answer some of the frequently asked questions that we hear from clients when we're talking about estate planning with them.
Our first question is, what does an executor or trustee actually do? So in handling the estate, the executor is legally responsible for sorting out the finances of the person who died, generally making sure debts and taxes are paid and that assets are properly distributed. The examples of some of the things that you might be doing as an executor include notifying banks of the death of the person, opening bank accounts in the name of the estate, making sure tax returns are filed, checking on required payments from IRAs, managing property and upkeep, preparing for the sale of property, attending to those digital assets and social media accounts, and the list goes on. Yes, you can ask for help from the estate planning attorney, but this is still a lot of work. And although we find people are very happy to take on this role, it's extremely time consuming and overwhelming. I oftentimes will recommend that people do look into hiring a professional fiduciary firm who can help with some of this work. They are typically charged by the hour. It's very reasonable rates.
Yeah, I mean, you can expect that your role as trustee or executor when somebody passes away, you can expect that to last up to 18 months. And I've seen it go even longer depending upon the complexity of the estate plan. Um, and it gets even more complicated or takes even more time when not only are you serving this role after a person's passed away, but if you're also the power of attorney or trustee while a person is incapacitated. So, you're doing all of that work that Lisa was mentioning, but you're doing it on an annual basis. So, if a friend or a family member asks you to serve as the trustee or power of attorney, I think that it really helps to think about it like it's a part-time job. You're paying medical bills, you're having discussions with doctors, you're having discussions with investment advisors and attorneys, and all of those things take up a material amount of time. The second question is, what should we think about and discuss before we meet with our estate attorney? I think that there's four key elements or maybe four critical questions to ask yourself when you are about to meet with or planning to meet with an estate attorney. The first one would be, who's going to make the important financial and medical decisions on my behalf during my lifetime in the event that I can't do that for myself? The second question that you would ask is, who would I want to raise my children if they're still minors? The third question is, who's going to receive my assets? I think that it helps. I break it down at the highest level into three different buckets in terms of who can receive assets from your estate. You've got heirs, which are individuals, and that can be anybody: children, siblings, friends, strangers. You've got charity as a second bucket. And then, of course, you've got government as the third bucket. The government comes in the form of estate taxes, which in the environment that we're in right now doesn't apply to a lot of people because the estate tax exemption is so high. But still, that is still a bucket that is makes sense to keep in mind. And so then the fourth question would be, now that you have that ideal breakdown of how much you want to go to heirs versus charity and maybe to taxes, is how should they receive these assets? You can structure it any way you want. You can have your heirs receive the assets immediately and outright, like they get accounts that are just turned over to them. You can have it held in trust for their benefit for their lifetime if you wanted to do that. You can provide them with access at certain ages. I mean, the options are really unlimited. So it helps to think about the ideal way that you would want your heirs and charity to receive assets before you go meet with an attorney. You don't need to know the technical details of it, but just conceptually, what would you want to have happen?
Great. Another question we hear is, what is the process that an estate planning attorney will take you through? Well, first, a good attorney needs to be an excellent communicator, but they also have to be a good listener. You'll likely have 2 to 3 different meetings with the attorney to acquaint them with your situation, and to time for drafting documents, to answer questions, and a third to sign documents. By the end of the process, you should understand your estate plan, have your signed documents, and marching orders as to how you might change titling of assets and beneficiary designations. And just a note that's super important, that if you have a revocable living trust, that all your assets ideally should be named, entitled in such a way so that they are covered by the trust. Our next question is, how often should the estate plan be revisited? Well, whenever there's a change in sentiment about how you want to leave your estate, or when you prefer another person to be your health co proxy, for example, a major life event will trigger a need to have the estate plan revised. Birth of a child, adoption, a new grandchild, marriage, divorce, or a change in your capabilities of your beneficiary. And also, of course, we might note the state taxes do change frequently. Maybe not in the last recent years, but at one point in time, estate taxes were an issue if you had estates over $600,000. So, absolutely necessary to see your estate planning attorney should estate taxes change.
And then what sort of general advice do you have? I hear that question a lot. I'd say I have two pieces of advice, and they're both related with each other because the issue that I see the most often is clients who have started down the road of either working with an attorney to have the documents drafted and they haven't completed it, or they're still sort of in that thought process before they've met with their estate attorney. So my thoughts are these: is estate planning is just as much about the present as it is about the future. And I think all else being equal, it makes sense, or knowing that all of these documents can be changed. Nothing that in these five main documents that we've talked about is permanent. You can revoke them, you can update them whenever you want. So I think knowing that, it makes sense to make sure that your present day circumstances are handled in the ideal way possible. If you don't have that sort of future contingency figured out already, that's okay. As Lisa just said, there's going to be tons of reasons along the way that you're going to be updating your estate plan anyway. So just make sure that the future is handled, and then you can start to deal with some of those other decisions out in the future when those come. I think the other related piece would be don't let perfect be the enemy of good. And I say that they're related because you don't have to get every last piece of your estate plan figured out. If you're 95% of the way there, just go ahead, meet with your attorney, get those documents put in place. Because at the end of the day, it's better to have something than nothing. We talked in an earlier section about the risks of not having an estate plan. And it can really work against both you as well as your heirs if you don't have anything in place.
Yeah, and I would add, don't underestimate the value of flexibility. Estate planning is an art and a science. The science, if you will, is that whole basket of technical tools and strategies. And the art is knowing how to judicially use these techniques in the most beneficial way so that the end result doesn't end up being unnecessarily complicated or inflexible. Another question we get is, what is our role as advisors in the estate planning process? So, Zach, you mentioned there were four critical questions to think about before seeing an attorney. Well, we might be able to help in those discussions with our clients. In some circumstances, clients have asked us to attend meetings, in which we're happy to do so with their attorney. And then we periodically will review the estate plan when we meet with clients from time to time. And since we are more likely to talk to our clients on a regular basis than our clients do with their estate planning attorney, it's likely that we're going to hear new information, new goals that would make us think that or suggest to the client that they should go see their attorney for a revision.
So thank you for tuning in to part two, frequently asked questions. In our next section, we're going to cover estate planning considerations for a young adult by studying the case study of Bob Bender.
Welcome to part three of our estate planning for every stage of life. I'm Lisa Peters, and I'm here with my colleague, Zach Mangels. In part one and two, Estate Planning 101, we presented the nuts and bolts of estate planning, why you should have an estate plan, a review of the documents typically put in place, and the frequently asked questions that we get about estate planning. In part three, we'll introduce you to Bob Bender as a young adult and discuss the estate planning issues he should address. I think many assume estate planning is for seniors or those facing health risks, but that's really not the case. There's some critical elements to have in place and considerations for those even with few assets, the wealthy, the young, and old. Let's start with our first scenario of Bob at age 18.
So this is Bob Bender. He's recently turned 18 and he's in great health. He's attending university and majoring in engineering. His assets are typical of most people in their late teens. He owns the car that he drives, and he has a small checking and savings account. Let's find out what Bob's estate planning needs look like.
If I could pipe in, I would just say if any parents or grandparents are viewing this, this is a great topic for your soon to be 18-year-old family member.
Yeah, very true. So at age 18, Bob's focus should be on establishing financial and medical decision makers. While he was a minor, his financial and medical decisions were made on his behalf by his parents. However, now that he's 18 and considered an adult in the eyes of the law, his parents are no longer automatically the de facto option for making those medical and financial decisions. Bob now has the right to choose these people. And I wanted to emphasize specifically that Bob was in great health to just to say that this isn't about, we're not making these suggestions for a young adult who's not healthy. This is for all young adults, whether they're healthy or not. And the reason for that is the number one cause of death for people in their teens and 20s is unintentional injury. And at age 18, Bob is right in the middle of that category. So, what are the documents that Bob should ultimately be looking to get in place? And you'll see here, so we've said that Bob is 18, but this applies to people their late teens and 20s, basically people putting together their estate plan for the first time. So, four documents. The first one is the healthcare power of attorney, which we explained in the previous video, gives another person legal authority to make healthcare decisions, including life and death decisions, on your behalf if you're unable to do that yourself. The second document is the Advanced Healthcare Directive, or the Living Will. Um, we also talked about what this document does in the previous section, but I'll share the story of Terry Schiavo to really indicate or to really drive home why it's such an important document to have. So Terry had a heart attack, and that resulted in permanent brain damage. And she was married, and her husband at the time had decided that that life support should be withdrawn. She just wasn't getting any better. Terry's parents felt differently, and they wanted the life support to continue. And they ultimately went to court over it. And I believe it went to the Florida governor. I think it went to Congress. And I believe even the president of the United States was involved at one time. All of that could have been avoided if Terry had her advanced healthcare directive put in place. And so to me, the case of Terry Schiavo is it's this reminder, that we're all human and we all have emotions, and our emotions, especially in these kind of challenging times, can cloud our decision making. And so if you can put something in place that alleviates that from the people who you love and who love you back, I think it's your responsibility to do that. So that's the importance of the Advanced Healthcare Directive. The third document is the HIPAA authorization. This gives your doctors permission to discuss your medical situation with others, including family members and other loved ones. The fourth document is the durable power of attorney, which again, we explained in the previous video, gives another person legal authority to manage your assets on your behalf. So as by way of example, let's say that Bob has decided to take a semester abroad in Rome. And while he's studying there, there's some sort of legal matter that needs to be handled stateside. Doesn't really matter what it is, but something legal that would require him to fly back and be present for himself. If he's named his parents to be his financial power of attorney, they can cover that for him so he can stay in Rome and continue enjoying his time there. So we've gone through the four documents that Bob should have in place as he's turned 18. Lisa, can you talk a little bit about how Bob would handle his financial accounts and the other assets that he owns?
Right. When there's a small, non-complicated estate, there's some simple, low-cost methods to transfer assets. One is by creating designations where they can be put into place, effectively transferring property without a will or trust. For example, Bob might have a checking and savings account, and he could actually add a transfer on death feature to that, and those assets would pass without any kind of will or trust. Let's say that Bob's parents helped him fund a Roth account and he would have named a beneficiary for that account. Again, that asset will pass without having a will in place. For the rest of the property, which is probably very modest, an affidavit can be filed for estates of roughly $150,000 or less. Finally, I wanted to mention that letter to family and friends that can direct items of sentimental value. Bob would note that he'd like his baseball mitt signed by Alex Rodriguez to go to his friend Mike, who happens to be a fellow baseball fan.
And let's maybe scroll forward a few years in time. Bob has graduated, he's in his 20s, he's working, and now he has some retirement plans and some equity compensation like restricted stock units, RSUs, or an employee stock purchase plan, ESPP. Um, so both of those assets require special attention. We talked in a previous webinar about how retirement plans have beneficiary designations that distribute outside of the will and trust. So Bob would want to make sure that he has the appropriate beneficiary designations on his retirement plans. And then for the equity compensation, that's not always as straightforward. Different employers allow their employees to handle these things or to handle those accounts differently. In some instances, you can directly title the account to the trust. I think we find more often somebody will need to put a POD or a TOD to actually transfer the assets into their will or into their trust if they were to pass away. So we've talked a little bit about the documents Bob should have. We've talked about how he should distribute the estates. Let's talk about now what he actually needs to do to get the documents drafted. I think the first place that Bob should look is to his parents' estate attorney. There's already a relationship that works there. Presumably, this estate attorney is already familiar with Bob. And I've found that a lot of estate attorneys also have an off to college package where they can get those 4 documents that I talked about put into place very quickly. If Bob didn't already have a relationship with the family's estate attorney or just decided he didn't want to work with an estate attorney, there are documents, all those documents can be found online from reputable sources, sometimes for free, often inexpensively. I know in California, the Advanced Healthcare Directive can be found at the Office of Attorney General's website. You can use websites like LegalZoom for a will, and actually colleges sometimes have templates of these documents that they host and that you can work with to get them drafted. My word of caution on this, though, is if Bob has any degree of complexity or any sort of uncertainty about what he wants the estate plan to look like, would be to stay away from these online resources and these free resources. Ultimately, when you have complexity, you want to have an attorney making sure that the right stuff appears in all of your documents.
Great ideas. Shall we move forward on the timeline? And we'll encounter some major life changes that require a revision of the estate plan. So I'll take the first one, marriage. Bob meets Carol. They're going to get married. And this is a great time to discuss their life goals and lay out each individual's assets and debts and how they want to distribute them should one pass away. And I want to digress a little bit and just talk a little bit about the nature of property coming into the marriage. Let's say Carol owns a home and they plan to live there as a couple. Is it their intent for it to remain Carol's separate property, or do they want to actually make the intention of creating this as a community property holding? There could be considerations related to careers and other assets. So what the couple does or doesn't decide here can have an impact on how property might be divided in the event of divorce. While this isn't an estate planning document, I wanted to mention that there are documents called prenuptial agreements that can be used to address property issues during the course of a marriage. But let's go back to estate planning. Let's say the Benders don't have an estate plan and the house remains separately titled in Carol's name, and she unexpectedly passes away a few years after they get married. State law for individuals dying without a will could prevail, and some portion of her titled residence, which essentially they viewed as theirs, might be directed to her living parent through the intestate laws and not to Bob. The couple might want Bob to have had complete control over this asset, but he might face a complicated process in dealing with his in-laws if they're not accommodating. And then I would just mention a second reason that would generate a revision of the estate plan would be a second marriage, for example.
Yeah, that's a great point. So I'll take the second and the third one here. So Bob and Carol are looking to purchase a residence. That would be another time or another indication of when they should at the very least get all of these documents put into place that we've talked about, but also a will and a trust. So real estate is often the largest purchase that people make, and often the largest single asset on many people's balance sheet. And typically, in order to get it, they also take on a lot of debt to do so in the form of a mortgage. And unlike retirement plans and life insurance, which have their own built in mechanisms for estate transfer, that's not the case with the real estate as well. So, because it's such a big part of your estate, both in terms of its size, but also just because that's where you live and that's where you spend so much of your time, it's really important to make sure that you have a will and trust that appropriately handle your residence. The third one, in my mind, planning for a family, the birth of a child, is the most critical reason why you should have an estate plan in place. So let's say that Bob and Carol just found out that they're expecting their first child, and they want to make sure that their baby is taken care of if they pass away prematurely. We've talked about estate planning as being important to distribute assets after you pass away. We've talked about why it's important, or how you can use it to name people to make financial and medical decisions on your behalf if you can't do so for yourself. And estate planning is also really important to ensure that your loved ones who depend on you are well taken care of if you pass away. So, part of the estate planning for the birth of a child, like I said, getting all of these documents in place, but making sure that there are guardians who are named to watch over your minor child for Bob and Carol. And then the second thing that they should be thinking about is if they do pass away, how would they want those assets to be held for their child's benefit? Typically, well, actually, always, minors can't own property. So while their baby is a minor, it's likely going to be held in trust or by some custodian. But you can set out, Bob and Carol can set out how they want those assets to be managed all throughout their child's lifetime if they wanted to do so.
Thanks, Zach. This brings us to the end of our discussion on estate planning needs for younger people from age 18 through adulthood in forming a family.
Welcome to our fourth section on estate planning. In our third webinar, we addressed the estate planning issues of Bob as a young adult, then starting a family with Carol and up through their working career. During that time, their plan focused on asset accumulation and protection. We're now going to jump ahead and revisit Bob and Carol's family when they're in their 60s. Different priorities have emerged now for them, priorities about legacy, such as what kind of impact will they leave and how do they want to be remembered. So their estate plan at this stage is now going to emphasize how they direct resources to family and community. So Lisa, can you start us off with an update on Bob and Carol?
Sure. Let's imagine for a moment that we were just learning of the couple's financial details and goals for the first time so that we can address the full scope of what they want to accomplish in their estate plan. Bob and Carol have 3 adult children now. 2 are married, 1 is single, 5 grandchildren. They have roughly 7 million in financial resources to meet their spending and gifting objectives. There's a primary residence and a vacation home in another state.
So we'll address all of these goals on the page, but I first want to point out that what you're seeing on the screen is typical both from what our clients express to us, as well as the type of conversations that we have with them. We're talking to our clients about these goals on an annual basis, and often more frequently than they're speaking with their own estate attorney. So it's very common that these goals evolve over time, And we actually are helping our clients. We're working with them to identify at what point they should go back and actually meet with their estate attorney. So I'll start by talking about the first goal. How much can we give to family and charity now without risk of depleting the resources that we need? As part of our financial planning process, we gather a complete picture of the vendor's assets, liabilities, income, and expenses. And then we create a projection, building in allowances for unexpected expenses like home repair and improvement, extraordinary healthcare expenses, things like that. And then we take this financial model and analyze the sustainability of the financial trajectory that they're on. So it's through this process that we can actually identify and quantify surplus funds that can be used for gifting to children and charity. Now, this isn't just a set it and forget it plan. Like, we don't create this one time and then we never revisit it again. This is going to be an ongoing conversation, an ongoing review of their financial trajectory to continually test out for feasibility to ensure that the vendors aren't at risk for running out of funds.
Great, Zach. I'll take goal number two. So Carol plans to leave most of her estate, their estate, to immediate family, but she's got a sister, niece, and nephew that she'd also like to include in her will. This is easily accomplished, pretty straightforward. You can leave any amount to any person you wish. Sometimes people use dollar amounts, others use percentages. And Carol might also include a statement to the effect that should her sister pass before she does, that her sister's portion be allocated to her niece and nephew. Goal number three, the vendors are concerned about Bill, their son's ability to manage his inheritance. Bob and Carol can choose to have his assets held in trust. The trust would specify the conditions under which he would have access to funds. They would also name a trustee who would manage the funds and make sure that the terms of the trust were enforced properly. Sometimes people will first think of a family member or a sibling to act as trustee in a circumstance like this. And it's not such a good idea because it could be awkward at best, or at worst, it could create significant resentment and discord within the family. So I would look into a local, well-established professional fiduciary firm who could act as an executor or trustee in a circumstance like this. Moving to goal number four. Federal estate tax is not a consideration for this couple because we can each leave 11 million to others when we pass away. However, in Washington state, unlike California, there's a much lower threshold at which inheritance taxes pertain. So each of us may pass 2.2 million on before estate taxes are considered. When you're a couple, the first death does not create a triggering system for this particular inheritance tax, but on the second death, it could. So typically we see testamentary trust brought out in the will that would essentially hold some of these assets in trust for the beneficiary spouse, thereby avoiding inheritance tax.
And I'll just add one point onto that. The current estate tax exemption is really high. The federal one is really high, but it is set to sunset, I think, sometime in 2025 or 2026, something like that. And the reality is that each time the government says this is permanent, this estate tax exemption is permanent, but I think in the time that I've been working in this industry, I've heard that like 3 or 4 times. So while the estate tax issue isn't relevant for the vendors today, it certainly could be in the future. And that's why it's important that we continue to revisit these goals over time. And then, so let's talk about the fifth goal. Bob wants to leave something to his university. So basically a gift to his university's foundation. One of the great things about people with philanthropic intent is that with proper planning, they can maximize the amount of money that goes both to their heirs and to charity. And so I think before I talk about how the strategy works, let me just back up and say, most people have a couple different types of assets in their estate plan. And I'll just break it down as retirement assets and non-retirement assets. Anytime an individual inherits a retirement plan, they're going to have to pay taxes anytime they take a distribution. So some portion of that money from an inherited retirement account is going to the government no matter what. The charity, though, well, they're a tax exempt entity. So if you were to give a retirement account to charity, and they take a withdrawal, they're not going to pay any taxes. So that money that would have otherwise gone to the federal government, if an individual took it, now gets to be kept by the charity. So what Bob can do is Bob can say, okay, I'll have my IRA go to the charity, and then my other assets, my assets in my trust, I'll give to my children or to my heirs instead. And when that happens, there's also something called a step up in basis for these non retirement accounts, which basically wipes out all of the embedded taxation there. So, what we've done just by moving around which person or which entity gets a specific account is we've eliminated all of the taxes that both of them would pay and therefore maximize the amounts that all of them get.
That's a great point, Zach. If we move to goal 6, Carol has been talking about money and investing with her two granddaughters. And so she wants to be sure that they, in particular, receive the few individual stocks she has. So it would be a very simple matter to open up a transfer on death account and then name the two grandchildren as beneficiaries and simply plop those stocks into the account. And that could be accomplished very simply. Otherwise, she would just simply pass these or transfer these while she was still living to them. For other purely sentimental items with modest financial value like furnishings, artwork, book collections, etc., the vendors would complete a letter to family and friends. And we talked a bit about this additional resource in estate planning in earlier part of our series, but they would complete that to indicate any special things will go to individuals. Last but not least, we have an important goal that the vendors would like that none of their family would encounter any worries or frustrations in dealing with settling their estate. And Zach, I think you had a great observation you made a little earlier in our series where you said once you yourself have gone through the process of settling an estate, that you really recognize how valuable it is to have everything buttoned up. And as we move into our 60s and 70s and 80s, we are looking beyond our life expectancy. We're thinking about our expectations for our children and grandchildren and what we'd like to see happen in the community. And having that estate plan, making sure it's done, it's up to date, and it includes everything that's important to us. It just delivers fantastic peace of mind. Another comment I would make is that some families have great communication among the family members and siblings, and they might sort of implicitly have an agreement about how things should happen. But this sort of informal estate plan is one you really can't rely on. You might find that everything does not go as well as you planned. So it should be a formal written plan that your beneficiaries can rely on. Zach, would you like to summarize the steps the vendors would need to take to ensure that their estate plan is put in place properly?
Yeah, sure. I think that there are four things that they would need to do. One of them you've already hit on. It's basically to make sure that your formal estate documents are not only in place, but also up to date. And up to date means, or reasons, I guess, why things could get out of date are the vendors have a different intention for who they want money to go to. Or instead of that changing, maybe the estate tax law changes around that. And then I think the third one, which is maybe the biggest one, would be if there's a change in the makeup of the family structure. You know, somebody's born, somebody passes away. That's always an opportunity to make sure that the estate plan is up to date. The second thing that they should do is they should put together the financial inventory and letter to family and friends that we talked about in one of our prior sections. In these two documents, you have a list of all of the assets, where they're located, things like that. So your beneficiaries know and your trustees and executors know exactly where everything's located. They know they're not missing anything. And this is also where you can list important information about passwords and insurance plans as well. And I think that it's important that you review these things, maybe semi-annually or at least annually. You can use the spring and fall equinox if you want to make sure you have a reminder to do it. But certainly the information that you would find on these 2 pages would change or could change frequently. The third thing that they should do is to communicate to communicate to executors, trustees, powers of attorney, all of these key people who are in their estate plan, communicate to them not only where the original documents are located, the five documents, the wills, trusts, so on, but also to provide them with a copy of the relevant documents as well, so they have them on file. I think the fourth thing is one that, at least in my experience, our clients don't think about frequently, but that is to introduce your family members to your estate attorney. I think that has a couple benefits. One, of course, is that if you pass away, you'll know, or your heirs will know who to call. But then the second thing is there's a trusted individual already in place, and that relationship is already known, and so it just makes things a little bit smoother when the second person passes away.
That's great. Zach, I don't know where this fits in our Bender case study, but I also want to mention that I've seen families do something for their parents as they age, for the family that strikes me. Those listening might have heard of legacy recordings. Families can hire a professional to interview and videotape your loved one, and it oftentimes will capture memories that wouldn't necessarily come through in family discussions. My sister and I did this a couple of years ago for my dad, and he's age 90 now. He's doing great, but we heard some things we hadn't heard before. One great memory he had to share with us was he would jump into the truck with his father, my grandfather, and they would drive 90 miles through gravel roads once a month to sing with an amateur barbershop quartet. And this was really a genesis of his love of music, and that early memory was something we hadn't heard him say in his own words. That was a treasure.
That's a really cool. As you're saying that, I'm thinking actually about my aunts and uncles and cousins who they sometimes just sit around a table while I'm there talking about stories about family members from decades ago. And I mean, I've usually heard those stories a few times, but when you hear it from them who witnessed it and experienced it, it brings a whole new like life to it. So that's really cool, and that's maybe something I want to do with my family as well. Okay, so let's wrap up here. So what you've just heard in this section is an abbreviated discussion of the type of conversations that we have with our clients. And in particular, when we're working with them for the first time, because that's when we're really digging in and really assessing all of their legacy goals. There's a lot of other topics that we could have spoken about as well. We could have talked about irrevocable trusts, such as charitable trusts and life insurance trusts. We could have talked about actual strategies for minimizing estate taxes, as well as ideas for who to name for alternate trustees and executors. But ultimately, we wanted to keep this relatively simple. As we're continuing to work with the vendors going forward, we're going to touch on these topics at least annually. We won't go into the same level of depth unless something happens in their lives that warrant that. And then, of course, we'll spend that time reviewing all of this information again with them. So at the end now of this 4-part estate series, if you've tuned into all 4, you have learned about the basics of the basic documents in estate planning, the common questions that we frequently come across when we're talking to clients about estate planning. And then, of course, you've heard about the estate planning concerns for 2 different people at 2 different points in their life. Not 2 different people, the same people, but at 2 different points in their lives. So as a final thought, I'll leave you with this. As financial planners, we are in the fortunate position to see how our clients' lives evolve over time. And depending upon what aspect of their financial life needs attention at any given point, we may be focusing, on retirement planning at one meeting and something else at a different meeting. But there's always some sort of interconnectedness. And I think you'll actually notice as we've gone through this, there's been several other planning topics that have come up related to retirement, related to philanthropy, things like that. And what we find as holistic wealth managers, people who talk about all aspects of financial planning, is that this approach serves our clients really well. We're able to connect the dots. We're able to say, oh, but what you're saying here kind of conflicts with this other goal in this other area of your financial life. we're also able to more readily find issues and troubleshoot things that might be on the horizon. And so at the end of the day, it's our hope that everybody gets to work with their advisor in that same way as well. And of course, if you're not, please give Lisa or myself a call. And then just I'll mention one last thing on this last slide here. If you'd like to learn a little bit more about estate planning, you can please visit privateocean.com/estate planning. And then if you'd like any of a copy of any of the resources that we've talked about throughout this series, please feel welcome to contact Lisa or myself. And our email addresses are below. Thank you.